This is an NBC News special report. Here's Lester Holt.
Good day, everyone. We're coming on the air with breaking news from Kentucky in the case of Breonna Taylor, the 26-year-old emergency room technician shot and killed by Louisville police back in March during a raid in her home. We're getting the announcement now of the grand jury's decision whether to press forward with charges against the officers involved. Let's listen.
County Grand Jury. In the matter of Commonwealth of Kentucky versus Brett Hankison, the Jefferson County Grand Jury charges as follows. Count 1, wanton endangerment in the first degree. On or about March 13th, 2020 in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun, into the apartment occupied by initials CE. Count 2, wanton endangerment in the first degree. On or about March 13th, 2020 in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into the apartment occupied by initials CN. Count 3, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by initials ZF against the peace and dignity of the Commonwealth of Kentucky. Mr. Foreperson, is that the decision of the grand jury?
Yes, it is.
Thank you. Sir, if you would please randomly select a number.
Division 13.
Division 13. Thank you, sir. The case will then be assigned to Jefferson Circuit Court, Division 13. Madam Assistant Attorney General, do you have a motion with respect to bond?
Yes, Your Honor. The Assistant Attorney General asks for $15,000 full cash bond for the defendant, Brett Hankison.
I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant. That concludes the business of the grand jury sitting for Jefferson County in September 2020. Thank you, ladies and gentlemen. You may be excused. I'm going off the record.
All right, we've been watching the judge in Louisville, Kentucky, announcing the grand jury's decision regarding the Breonna Taylor case, a woman shot to death in her own home during a police raid. It appears only one of the 6 officers who was involved in that operation has been charged. Let's go to Gabe Gutierrez right now in Louisville. Gabe, walk us through what just happened.
That's it. Hey there, Lester. Well, we're just starting to get reaction here. We're at Jefferson Square Park in downtown Louisville, and the decision is starting to trickle in. But I want to point out what just happened. There were 3 officers here that were under investigation as part of these proceedings. One you just heard from right there, Detective Brett Hankison. He is significant because he is the only one of those 3 officers that had previously been fired. In his termination letter, the police chief wrote that he had wantonly and blindly fired into one of the apartments. So he was appealing his termination, but it appears that the grand jury, the only officer that the grand jury has returned an indictment on, has been Brett Hankison for the lesser charge of wanton endangerment. Prosecutors had said that he had fired into not just Breonna Taylor's apartment, but another apartment as well. And according to the police chief in his termination letter, that did not follow the use of force policy in the Louisville Police Department. The other 2 officers that were part of this investigation, Sergeant John Mattingly and Miles Crossgrove, they remain employed by the department. They are still on paid administrative leave. Lester, what's significant here is that we did not hear any charges against those two officers. As part of all this and part of a broader context here, the Breonna Taylor case has really set this community on edge for more than 6 months. There have been more than 100 days of protests where many of the protesters have been asking for murder charges in this case. You discussed the details of this. This was a botched raid back in March of this year, and this case got national and even international attention, especially following the death of George Floyd in Minneapolis. Her name, Breonna Taylor's name, has become a rallying cry for social justice protests across the country. It's important to note that Breonna Taylor's family was asking for second-degree manslaughter charges against these officers. They were not going so far as to go to ask for murder charges here, because even the family realized that, in their words, it would be a long shot to get a murder charge in this case because of Kentucky's self-defense laws, which would allow potentially an officer to fire back. The police have insisted from the beginning here, and the police union has reiterated this, that they feel the shooting was justified because Breonna Taylor's boyfriend, Kenneth Walker, had fired upon the officers first, and that the officers, according to the police union, only returned fire once they were fired upon. But again, the significance here, Lester, only one officer has been charged by the grand jury, a charge of wanton endangerment that is less than what the family had been asking for. 2 other officers, it appears, here will not be charged, and we're now awaiting comment from the Kentucky Attorney General in the next few minutes. Lester?
Gabe Gutierrez, thank you. NBC News legal analyst Danny Cevallos is here. Danny, walk us through this process now and these charges. 3 counts of first-degree wanton endangerment. Looking at the range of potential charges, where does this fit in?
On the low end, wanton endangerment is a Class D felony. It involves not an intentional act, but something manifesting an extreme indifference to human life, something incredibly dangerous and arguably knowingly dangerous. But it is a Class D felony in Kentucky, which I understand only calls for 1 to 5 years imprisonment, and then potentially the opportunity for what we call pretrial diversion. And, across the country, pretrial diversion is basically your one free bite of the apple. If you don't have any significant prior record, then you can get a diversionary program that could keep you out of prison. You see it a lot in DUI cases and other lower level type misdemeanors and felonies. So in the grand spectrum of potential charges in this case, this is arguably on the lower end. It is a felony, but it is a Class D felony, and looking at a maximum of 5 years for each count.
Given the fact the grand jury took a pass on the other 2 officers, what does that tell you about any potential case that might have come against them? Was that going to be a more difficult mountain to climb?
This was always a difficult case, but Officer Hankinson appeared to be the easiest target for the grand jury because there were reports already that he had fired, and I'm quoting wildly, into the apartment. But in this case, there was always going to be a challenge due to what's called castle doctrine, the idea that as long as somebody is lawfully standing where they stand, they can use force to defend themselves. It gets very tricky with police, and this is why so few grand juries end up indicting police officers who shoot unarmed civilians, because police are the one segment of our society that is authorized to go on the offensive, to execute a warrant, to come into your home and lay hands upon you. So you have that competing kind of castle doctrine where you have somebody in their home who believes they're being assaulted or that they're being burgled. And on the other hand, the police who have a warrant that is at least ostensibly lawful. And again, even if it's ultimately proven to be a warrant that is not based on good information, as long as the police relied on it in good faith, they may be protected. So the bottom line is it is very, very difficult to charge police in cases like this.
All right, Danny, thank you. We're standing by for a news conference from the Attorney General of Kentucky with a bit more texture regarding what's happened. But I want to go to Jonathan Capehart now, an NBC News political contributor. Jonathan, what message does this decision send, and how could it impact voters?
Well, Lester, I think the message that it sends is that justice is hard to come by if you're African American and dealing with law enforcement. I think Danny laid out the legal issues just right. I think anyone who has been paying attention to other cases like this, it is extremely difficult for the police to be held accountable in the way that communities would like them to be held accountable for, because of the way laws are written, because of the power that police have. I think in the case of Louisville, the city has been getting ready for days now for what could come down from the grand jury. And I think now it is incumbent upon community leaders, elected officials, to speak to the community, to talk to them, explain what's going on, and to also make it clear that the better way to honor Breonna Taylor is to demonstrate, to make your voices heard, but to do so in a way that doesn't give other people excuse to do damage or to mar her memory.
Jonathan, thank you. An NBC News political analyst and Washington Post columnist Eugene Robinson joins us now. Eugene, obviously it's been a summer of outrage over interactions between African Americans and police. This particular case, however, was unique in its circumstances. An innocent person in their home suddenly confronted with police officers firing into that home. You could argue this transcends a lot of the other issues, and it's something that would strike a note with anyone.
Every case is different. This one is really different from the others because, as you said, Breonna Taylor was an innocent person in her home, and for no fault of her own, she ended up riddled with bullets, literally, shot to death multiple times by police who were executing a no-knock warrant, an unwisely granted warrant, but perhaps legally granted, legally approved, at least by the lights of the legal system and as far as the police officers knew. So I think this was always going to be difficult to get murder or manslaughter indictments against the police officers. But I think a lot of people will be disappointed, and a lot of people will be angry that the one officer who was charged is not being charged for firing into Breonna Taylor's apartment at all, apparently, if I understood correctly, but firing indiscriminately into another apartment in the complex, and that's so. To a lot of people, it will look as if Breonna Taylor's wrongful death is not going to be punished, and that's a problem. That's the vagaries of the legal system. But as you said, it's been a very difficult summer, and this is going to be a difficult pill for a lot of people to swallow.
All right, Eugene, thanks. So we saw some pictures there in Louisville. A lot of people on the streets. They primarily appear to be reporters. Obviously, huge interest in the announcement that came down just a short time ago. 3 charges of wanton endangerment voted on against one police officer, now former officer, who actually fired the weapon during that no-knock raid we were speaking of a moment ago. Blaine Alexander at the Louisville Metro Department of Corrections. Blaine, we know that the city has been put on a state of emergency prior to this announcement in case there are any outbursts or violent reaction. And we know that protesters are gathering right now. Talk about the mood and what's happening.
Lester, I certainly don't think it's a stretch to say that the city of Louisville is preparing for the worst, and that's kind of the mood that we've seen all day. I'm standing in front of the Department of Corrections. You see boarded up barricades here on this street. If you look over here a little bit, you see the police department, boarded up windows. And Lester, this is really what you see by and large if you go a block away, 2 blocks away. If you walk through downtown, largely this is what you're seeing. Trucks blocking off traffic, windows boarded up, people preparing for what they fear will be some sort of unrest tonight. Now, I've got to say, in talking with protesters since I've been here in Louisville, traveling here a few weeks ago, they have been very clear in what they wanted to see and what they believe would be a satisfactory outcome. And they said all along that they want to see the 3 officers involved arrested. Now, even when I was speaking with an organizer yesterday, he's been in the streets of Louisville now protesting for months, and he said that he believes that anything less than that would be a gross miscarriage of justice. So that's the backdrop that that we have. That's what we have now, knowing what the decision is. That's kind of the concern as we go into the night and what we could expect coming up. Lester.
All right, Blaine, thank you very much. We're now joined by NBC News legal contributor Barbara McQuaid. Barbara, talk about the impact of these three charges, which were, as we talked about, on the lower end of a range of options here, and what message that sends as we look at other cases involving interactions and violent interactions between police and African Americans.
Well, Lester, I think this case is a great demonstration of the difference between law and justice. It seems that these crimes are what the grand jury thought most appropriately fit the crime, and yet I think most of us feel a sense of outrage that a life was lost and the charge is only reckless indifference. It seems that second-degree manslaughter, which is for wanton disregard and a death results, would be the more appropriate crime here. But one of the things to remember is how favorably the law is written for police officers. I think when most of us hear about an attack like this, we put ourselves in the shoes of the victim. That is more akin to our experiences. And we think about Breonna Taylor sleeping, doing nothing wrong, and suddenly her life is lost. But the law looks at the perspective from the reasonable officer on the scene. And so from that perspective of shooting into these windows, the reckless disregard without an intent to kill does allow for mistakes. It allows for quickly evolving situations, the need for split-second decision-making, and says we do not look at the 20/20 vision of hindsight. So all of those ways stack the deck in favor of police officers and often leave us with this feeling that justice is not served.
All right, Barbara, thanks. I want to let folks know we expect now about 2 minutes away, we're going to hear from Daniel Cameron, the Attorney General, with more on that grand jury decision today. Before we go to that, let me quickly go to Yamiche Alcindor. She's White House correspondent for the PBS NewsHour and an NBC News political contributor. Yamiche, there was a settlement, $12 million settlement with the family just a few weeks ago. They had been continuing to call for justice. Do we know what their reaction is and what they have been braced for?
I don't know their reaction just yet, but what I do know is that her family, Breonna Taylor's family, have been really bracing for the worst because it's so rare for police officers to be charged in connection with killing someone, especially, of course, African American. And what I've been told is that the family was hoping that all three officers would be charged with a much more stiffer sentence. And of course, now we only have one officer in this wanton endangerment charge, three of them. So my sense is that the family is going to be severely disappointed. There was also some pushback that they received remarkably for the fact that they got $12 million. And their response was, well, how much is your daughter's life worth? And money is not what we were after. What we were after was these police officers being held accountable. My sense is that they're not going to feel like these officers were being held accountable. They are, of course. I'm happy that that settlement was reached, but this is really going to be a sad day for them and a sad day for a lot of African Americans that I've been talking to who are bracing for these officers to not be charged in a way that feels as though Breonna Taylor's life is really being honored and valued in a way that she would be if she was, frankly, someone who was not African American.
All right, Yamiche, thank you. We're looking again shots from Louisville. There are people who are gathering right now. There is going to be disappointment. There is going to be outrage. Hopefully there will be calm. Let's go to Gabe Gutierrez right now, who can give us a sense of the reaction you're seeing, at least there around that memorial for Breonna Taylor. Gabe?
Hi, Lester. I just want to point out exactly where we are. We're in Jefferson Square Park. The Breonna Taylor Memorial has been just over there. Just over here, there's been a crowd that started to gather. Certainly a lot of anger building here after the announcement of only the wanton endangerment charge against one of the officers. As we're walking over here, Lester, again, there is a lot of frustration that is built here. As you've heard, protests have been mounting here for more than 6 months after the death of Breonna Taylor. And now you can see here on the streets of Louisville, there's already anger starting to bubble up. A curfew is in effect tonight, but local officials had anticipated that this day could be extremely volatile. You already see people yelling, "No justice, no peace," Lester. And there's an increased police presence. As Blaine was talking about earlier, There are dump trucks that have blocked off more than 25 blocks or so here in downtown Louisville. This is the place where a lot of the violent confrontations of the last several months had happened. And during much of the day, over the last couple of months, this area has been peaceful during the day. However, there have been some confrontations at night, and the concern is that this frustration could bubble up here throughout the evening over the last several hours. So again, a little bit of confusion here, some tension starting to bubble up. The crowd is moving off in that direction. Again, in frustration, you hear a lot of chants of no justice, no peace. And the hope is here that this does not turn violent. But from some of the protesters that we have spoken with already, there is deep frustration here. And there's deep frustration here, and certainly a lot of emotion here. Lester, I'm going to send it back to you.
Yeah, we'll take it away. All right, Gabe, thanks very much. I want to go back to NBC News legal analyst Danny Savalas. I want to touch on something that Eugene Robinson and I were speaking about a moment ago. There's 3 charges of wanton endangerment. Did any of them apply to the actual firing of the weapons into Breonna Taylor's home, or was it other homes?
Yes. Yes, exactly. The end of your question gives us the answer. It was the firing of the weapon and the bullets that went into other apartments. None of the charges appear to be for causing the death of Breonna Taylor. And that reflects the difficulty that a grand jury must have had, and the prosecutors in presenting their case, with any causation of death of Breonna Taylor, because that would have brought into play self-defense, Castle Doctrine, all of the issues, all of those defenses that Barb McQuaid talked about, all of those benefits and advantages that police have when defending cases like this, the privilege that they have that no other citizen has. So it seems to me that the easier case to make was wanton reckless endangerment by firing bullets into a neighboring apartment, because if any of those charges relate to causing the death of Breonna Taylor, any kind of charge from first-degree murder on down to negligent homicide, then that brings into play whether or not the police were justified and whether or not they acted in lawful self-defense. And that's a thorny issue that it appears neither the grand jury nor the prosecutors wanted to deal with.
We're going to hear from the Attorney General momentarily, but while we wait for that, let me ask you about the whole idea of going to a grand jury other than a DA on its own accord making that call. What was the thinking there, you suspect?
Grand juries, I'm a jaded, biased criminal defense attorney, but the challenge with grand juries, as we see it, is that they are secret. And in police shooting cases, because grand juries are generally a one-sided affair, they're the prosecutor's show, then the prosecutor can choose or cherry pick which evidence they want to present. If they want a conviction, they can put on the very best case possible if they want to indict a civilian. But when it comes to police cases, prosecutors are often accused or criticized of coming into grand juries and maybe slow walking or not presenting the evidence with as much vigor as they might if it were a citizen. And because they're highly secretive, most of us in the public will never find out what went on in that grand jury room. So that is a common criticism of the grand jury procedure in police shooting cases. As a defense attorney, having never been inside a grand jury room myself, I can't say from personal experience, but that is a common critique.
All right, if you're just joining us, one of the officers involved in the shooting that claimed the life of Breonna Taylor has now been charged. Indictment coming down from a grand jury. 3 counts of first-degree wanton endangerment against the man you see on the screen, former officer, former detective, Brett Hankinson. Let's go to Blaine Alexander right now in Louisville, where, as we saw, the emotions are beginning to spill over a bit. Blaine, can you set the scene?
Absolutely, we can, Lester. And in fact, we've moved down the street just a bit since the last time we talked to you. As we were in our live shot, we had several people, several protesters from inside that square come over to us and to our crew and just demand that they wanted us to move, said that we were not welcome there. They didn't want our cameras pointed in their direction, and we were told to move. So we did that as we see the crowd kind of finishing up, marching up behind us. But we're also getting reaction now from Attorney Benjamin Crump. Of course, he is a high-profile attorney involved in many of these cases who has been represented defendant Breonna Taylor's family. And he tweeted not too long ago, once the results came down, "We urge the Attorney General to accept this recommendation ASAP." And then he adds, and this is notable, "While not fully what we wanted, this brings us closer to justice for Breonna Taylor." So in that tweet, you hear him note the fact that there is only one officer, the officer who was terminated, being charged in this. And Lester, I have to say that when this came down, a lot of us were kind of listening in real time. Many of the people in the park were listening in real time. And as soon as those three counts of wanton endangerment were announced, you heard kind of a silence, a still silence, as though they were waiting for more. And then when it was clear that that was the end, that's when you heard one person shout. That's when you heard another person and another person shout. We saw something being thrown. So it was almost this kind of disbelief that hung in the air from the people that we were observing, that there was really this unbelievable feeling that that was the only one. I will say the other thing, though, is that we've kept hearing is that they want 3 officers arrested. And so even though Attorney Crump has said, yes, it brings us closer to justice, just from the reaction that we've seen here from the people that I've spoken to, it does not seem to be enough. Lester.
All right. We're going to let you perhaps move your location a bit. Thank you. And NBC News political analyst and Washington Post columnist Eugene Robinson is back right now. There will be, and there are certainly calls for calm. As I noted, there's going to be outrage and anger, too. Given the political lens that this will be seen through inevitably, will those calls take on a greater meaning?
Yes, they will. Everything takes on a greater meaning because we're just a few weeks ahead of an election that many people believe is the most important of our lifetimes. And one of the issues, one of the things, the umpty billion things that have happened this year, one of the really big things has been this reckoning with systemic racism, this reckoning with police violence, particularly against African Americans. And this is a case that everyone has talked about and everyone knows about, and everyone has been waiting for months now for some sort of resolution on the legal side, something from prosecutors. And so, as Wayne Alexander was saying, you heard those 3 charges against one officer, and you kind of waited for what was coming next. And when nothing came next, I think that is shocking to a lot of people. I mean, let me add my voice to those who are calling for calm and for if people want to protest this decision, for protesting it in a peaceful way. But one understands that after letting the sort of expectation build for so long, and then to deliver what seems to be, to a lot of people, to be a kind of de minimis result. That's not going to make a lot of people happy, I think, and not going to satisfy a lot of people that the death of Breonna Taylor. After all, Breonna Taylor was not armed. Her boyfriend, who was in the apartment with her, thought somebody was breaking in. He was armed. He did fire a shot. But she was not. She was, and that, so was there more than just a sort of wanton disregard for people in some other apartment? Wasn't there some other crime that took place? Wasn't there at least wanton disregard for the life of Breonna Taylor? And that does not seem to have been charged in this case.
Eugene, thanks. We want to take you down to Louisville. The Attorney General Daniel Cameron now is going to make his first comment since we got word of the grand jury decision to charge one officer in the Breonna case.
Thank you for joining us today. I know that many in Louisville and across the Commonwealth and country have been anxiously awaiting the completion of our investigation into the death of Miss Breonna Taylor. Prior to this announcement, I spoke with Ms. Palmer, Breonna Taylor's mother, to share with her the results from the grand jury. Many of you in this room know that I had the opportunity last month to meet in person with her and other members of Ms. Taylor's family. including Ms. Bianca Austin and Ms. Janiyah Palmer. I want to once again publicly express my condolences. Every day, this family wakes up to the realization that someone they loved is no longer with them. There's nothing I can offer today to take away the grief and heartache this family is experiencing as a result of losing a child, a niece.
All right, we have briefly lost the audio of Attorney General Daniel Cameron, who's making his first comments since the grand jury announcement of just a few minutes ago that they were forwarding three charges against former Detective Brent Hankinson, 3 counts of wanton endangerment in the first degree. We've already seen images from the streets of Louisville of people expressing their disappointment, emotions beginning to flow over, and certainly some anger. But right now there is calm, is the best we can tell, in Louisville as people process this information. Breonna Taylor, you may recall, in March in her own home, was confronted by police officers in a no-knock warrant. Opened fire. The officer that fired Brett Hankinson, the one now facing those charges. Let's go to Gabe Gutierrez as we try to reestablish audio from the Attorney General. Gabe, if hopefully you move to a easier situation right now, you can tell us a bit more about what's happening there.
Sure, Lester. Well, as when you last heard from us, frustration was building here among some of the protesters. I'm actually joined here by Christina Johnson. You've lived in Louisville for more than 40 years, right? And you've been protesting over the last several months. Tell me your reaction to the charge against the one officer and the lack of charges against the others.
Disgusted. I was hopeful. That a little empathy. I was hopeful that a little compassion would visit. Didn't happen. $15,000. I can get you out tonight for $15,000.
What do you think happens to this city? The local authorities, of course, were worried that there would be, potentially a very volatile situation if these officers were not charged.
Yeah.
As a longtime resident of the city, how worried are you for what happens next year?
I'm extremely worried. One, because we're praying that some of us will start the healing process.
Christina, I want to thank you very much. Lester, I'm told we have the news conference again. I'm going to send it back to you. Thank you for talking with us.
All right, Gabe, once again, here's the Attorney General.
By a state-led investigation. With this in mind, our investigation focused on the events that took place in Ms. Taylor. Here with me today. I
think we got it back.
Thank them for their tireless work. Women are true public servants who for months have shown up every day with a desire for one thing, and that is to seek the truth. We decided while we would examine materials gathered by LMPD's Public Integrity Unit, we would need to conduct our own independent investigation and start from scratch in the interest of thoroughness, fairness, and finding the truth. There was no video or body camera footage of the officer's attempted execution of a search warrant at Ms. Taylor's footage. Fairness, and finding the truth. There was no video or body camera footage of the officer's attempted execution of a search warrant at Ms. Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI crime lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday. As long as the case is making its way through our legal system, I can only speak in general terms about our independent investigation and findings. As the prosecutor, I am prohibited by the Kentucky Rules of Professional Conduct from making public comments that could in any way prejudice this case as it moves forward. Each state has different rules about what prosecutors can and cannot say. The Kentucky rules are clear that I'm prohibited from making comments that could sway public opinion or heighten public condemnation of those involved in the case. These are crucial rules to ensure due process under the Constitution. When prosecutors prematurely release information about the case to the public, it can risk justice by poisoning the jury pool, violating the accused's rights to a fair trial, and even jeopardizing the final verdict. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives Cosgrove and Hankinson had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in a proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended, in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired one shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankinson's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the 3 officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective Cosgrove. Our office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both law enforcement agencies use similar equipment and analysis, and each lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Second, the KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be completed. With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team, the grand jury voted to independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? We as a community must make this decision. I understand that Ms. Breonna Taylor's death has become a part of a national story and conversation. But we must also remember the facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions. At the end of the day, it is up to us. We live here together. We work here and raise our families here together. I urge those protesting on the streets to remember this. Peaceful protests are your right as an American citizen. Instigating violence and destruction are not. I've spoken with both Mayor Fisher and Governor Beshears in the days leading up to this announcement, and I urge them to do what is necessary to maintain law and order and to protect our cities and our people. We have a long road ahead, both as we pursue this case through the criminal system and as we address the pain in the Louisville community. I'm committed to being part of the healing process. When tragedy occurs, we must mourn. We must also do everything we can to prevent it from happening again. Today, consistent with that view, I'm announcing that I will create a task force to review the process for securing, reviewing, and executing search warrants in Kentucky. The task force will consist of a variety of stakeholders, including citizens, members from the law enforcement community, representatives from the judiciary, defense attorneys, and elected leaders. I'll be issuing an executive order in the coming days to create this task force. I believe conducting a top-to-bottom review of the search warrant process is necessary to determine if changes are required and establish best practices. You have my word that I will also vigorously prosecute the criminal charges announced today. I can assure you that my team of prosecutors will continue to give this case their attention and time. We'll also continue to support the good men and women of our law enforcement community who put their lives on the line every day to protect and to serve. And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together. Thank you, and God bless. I'll now take some questions. I won't get into the specifics of the makeup of the grand jury.
Yeah, Mr. Cameron, you mentioned that Breonna Taylor was hit by 6 bullets. You identified the one that killed her. Who shot the other 5 bullets, and did any of Hankinson's bullets hit Ms. Taylor?
Based on the evidence, there's nothing conclusive to say that Detective Hankinson's, any of his bullets hit Ms. Taylor.
I'm just curious
Yes,
what
sir.
your message would be to the family and those who support her in the community, because based on what you're saying today, the grand jury basically found that none of the officers involved are directly responsible for Breonna Taylor's death.
Well, as I said from the beginning, and I appreciate that question, this is a tragedy. And sometimes the law, the criminal law, is not adequate to respond to a tragedy. And I fully acknowledge that, and I know many that are watching today and those that are listening recognize that as well. But the response is that the grand jury was given all of the evidence, presented all of the information, and ultimately made the determination that Detective Hankinson was the one to be indicted.
To be clear, did your special prosecutors make a recommendation to the grand jury?
Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankinson.
General Cameron, one question. Firing in self-defense, do you think state law needs to be changed?
I'm sorry, say that again?
When it comes to officers firing back in self-defense, do you think the current state law needs to be changed with cases like this?
Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective Cosgrove and Sergeant Mattingly were justified in returning fire because they were fired upon. I'll leave it to others to make determinations. We have vigorous self-defense laws in this state, and that is something that existed prior to this case. I'll let others make judgments about that. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
If a wanted endangerment takes place while there is a death involved, would that not be a manslaughter charge? If there was a death that occurred during a wanted endangerment?
Well, Chris, to your question, I think it, again, is important to step back and recognize that what we did was uncover all the information and facts related to the morning of March 13th, and then provided that information to the grand jury. The grand jury had every piece of detail needed to make their assessment and their judgments. And ultimately, their conclusion was that the decision needed to be made to indict Mr. Hankinson.
Mr. Cameron, Rukmini Kalimaki with the New York Times. Right here,
sorry,
sir.
yes,
Hi,
ma'am.
2 questions for you. Number 1, you said that she was shot 6 times, yet her death certificate says 5. Can you please explain the discrepancy? And the second thing is journalists in this room, myself included, have taken apart that apartment complex looking for witnesses to the point that you made about the knocking and announcing. Of a dozen witnesses that I spoke to, only one, a man who was directly upstairs, heard them announce. Do you think that's enough in the middle of the night when somebody is asleep for just one person in a tight-knit apartment block to have heard that? Is that a sufficient way of announcing?
Well, let me try to answer your second question first. Your question was, is it enough for me? I think the more pertinent question is, what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all the testimony and made the determination that Detective Hankinson was the one that needed to be indicted, knowing all of the relative points that you made. As to your first question, can you repeat it one more time?
Her death certificate says 5, and yet you are saying 6. Today's the first time I'm hearing 6.
Yes, sir. So there is a bullet that was lodged, and bullet might be too generous a term. There was an object that was lodged into into one of her feet, and so that is what is being referred to as the 6th, I guess, projectile.
Are you going to release the full? Are you going to release the full grand jury report?
Can you say that one more time?
Are you going to release the full grand jury report?
Well, I am right now, because there is a pending indictment. I think it is our practice, and because there is an ongoing FBI investigation, to revisit that question. But at this point, I don't think it's appropriate for us to release any information.
And just for clarification, you said that Hankinson fired 10 times from the outside into apartment 4 and into apartment 3, but no conclusive evidence any of those shots hit Taylor. Can you expand on that just a little bit more?
Well, that is what the evidence shows, is that there was nothing conclusive to demonstrate that any of his bullets hit.
The door open for the fact that maybe one of the shots did hit her, or?
Well, again, all the evidence was given to the grand jury, and they made the decision that wanton endangerment was the charge to file or to indict against Mr. Hankinson.
Okay, and thank you.
Yes, Wendy. Well, your last question about providing information. In any investigation, criminal investigation, the best practice, and this is whether on the state or federal level, is to not make too many specific comments about the investigation because you do not want to compromise that investigation. There are also ethical considerations as investigators and prosecutors that we're responsible to abide by as well. Some of those obligations continue now because we have a responsibility to pursue the prosecution against Detective Hankinson. It's my judgment very early on that we needed to take this case in the Attorney General's office. As you know, the Commonwealth's attorney was conflicted out of this case because of another matter that he was pursuing. I could have farmed the case out to another Commonwealth's attorney in one of our 120 counties. Instead, I did not do that because the resources that we have to bring to bear and the relationships that we have with our federal partners, in my judgment, were needed to uncover the truth in this case. And part of the reason the investigation took so long is because we needed to make sure that we were doing a thorough job of looking at all the facts and gathering all the materials, interviewing witnesses, making sure that all of our people felt confident in their presentation to the grand jury. I will remind you, as late as Friday, we were still interviewing people in this case. And so the length of it is because this case deserved thorough and fair analysis. That was needed and deserved by Breonna and by her family, for the officers involved, for the community of Louisville, and for the Commonwealth. We needed to have a thorough investigation. We also got the FBI involved in terms of the ballistics report. We needed additional, their ability to scrutinize and make an independent assessment as well. And so the length of the investigation was a reflection, I hope people understand, of how important it was that we got this right. We didn't want to rush it, and we did not. And I'm grateful to the team that is behind me for the work that they did. Look, over 200 years of combined experience. These are prosecutors and investigators who don't care about political distinctions, don't care about influence in any particular regard. What they care about is the truth. And we presented that to the grand jury.
Sir, sorry.
I'm sorry. I won't get into what our private conversation was. Yes, ma'am.
Yes. What do you say to people who say this is just another example of the Black community not getting full justice? And what specifically do you plan to do to calm a community that's long been hurting? And do you understand that anger that people might feel?
I certainly understand the pain that has been brought about by the tragic loss of Ms. Taylor. I understand that as a Attorney General who is responsible for all 120 counties in terms of being the chief legal officer, the chief law enforcement officer. I understand that. I understand that as a Black man, how painful this is. And which is why it was so incredibly important for make sure that we did everything we possibly could to uncover every fact. And I know, look, this team, myself, the members of the representatives of the Attorney General's office have taken a lot of criticism and scrutiny. But that scrutiny in many ways was misplaced because there was not a day that people in this office didn't go to sleep thinking about this case, and it wasn't a day where the first thing on our minds is getting to the truth in this case. And obviously, again, the criminal law is not meant to respond to every sorrow and grief, and that is true here. But my heart breaks for the loss of Ms. Taylor, and I've said that repeatedly. My mother, if something was to happen to me, would find it very hard. And I've seen that pain on Ms. Palmer's face. I've seen that pain in the community. And what our responsibility in the AG's office was to make sure that we uncovered every fact, that we utilized every resource that we could bring to bear to uncover the facts and the truth, and that's ultimately what we presented to the grand jury. On the question of what I'm going to do, I've talked to partners in the community about helping to be a constructive member of any conversations moving forward. I recognize in my remarks, I mentioned the fact that we'll be establishing a task force in the coming days ahead to look at best practices for warrants. So there is a lot that I can do in this platform to help.
Okay, sir, this is Maria Sacchetti with the Washington Post. Just had a couple of quick questions,
I
please.
hear your voice. Okay.
Hi,
yes,
sorry, over here in the back. Just wanted to double check. Did the grand jury ever consider the charges of manslaughter, reckless homicide? And if not, could you please explain why? And do you anticipate any other charges in this case?
I apologize. Could you say that a little louder? Sure. I think I got...
Sure. did the grand jury ever consider manslaughter or reckless homicide or those kinds of charges? And if not, please explain why. And do you anticipate any other charges, or is this it?
I won't get into the specifics again of the proceedings themselves are secret, but what I will say is that our team walked them through every homicide offense and also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
Attorney General, so can you go into the confusion over the fatal shot that was fired and kind of what the issue was there in terms of determining that? And then also, did you present to the grand jury with any charges against Mattingly and Cosgrove?
Well, so as to your first question, what I think you asked about was
confusion over the fatal shot.
Yes, the reports that were provided to us by the Kentucky State Police and then the FBI as it relates to ballistics. So initially we got the report from Kentucky State Police, and it was inconclusive about making a determination into that fatal shot. And so again, with the relationships that we have with our federal law enforcement community, and namely the FBI, I thought it imperative that we utilize that resource. And so they undertook an independent analysis and review of and conducted or provided a ballistics report. There is nothing that this team was able to glean suggesting that there was an objective reason for why FBI was able to conclusively or definitively state that Mr. Cosgrove fired the fatal shot. Both, again, KSP, their lab, well-regarded, well-respected, FBI, equally regarded and respected. That said, it certainly creates some issue in terms of providing that information to the grand jury and providing that at any subsequent prosecution. And so it was, from our judgment, important to provide both of those to the grand jury and then ultimately let them make a determination about what to do with that information.
And were they presented with charges for Mattingly or Cosgrove?
All right, we are watching a news conference with Daniel Cameron, the Attorney General of Kentucky, taking questions about the grand jury decision today in Kentucky to file 3 counts of first-degree wanton endangerment against one of the officers involved in the Breonna Taylor raid. Those charges specifically related to bullets that went into a neighboring apartment, not into Breonna Taylor's apartment. And so, as I bring in NBC News legal analyst Danny Savalas, Danny, if I understand this correctly, no one is being held criminally liable or criminally accountable for the death of Breonna Taylor.
That is correct. They're being held criminally liable for endangering people when bullets struck another apartment. And you saw the reporters key in on this. This is going to be a hot issue in the next few days. If the grand jury concluded that the bullets that went into a neighboring apartment were fired with some wanton recklessness, then how do they say that the bullets that entered Breonna Taylor's body were somehow not fired with the same wanton recklessness? And again, we get back into that force field that police generally have. They have a warrant allowing them to come into the premises. Then they have the self-defense argument. But it result in a very peculiar situation where you have bullets that hit nobody. Those are wanton and reckless. Bullets that killed someone, well, those bullets, those are different bullets. And it'll be interesting to see how the Kentucky Attorney General defends this in the coming days.
All right, thank you for that clarification. Let me bring in Blaine Alexander. She is in Louisville, where protesters have certainly started gathering to express their disappointment and even outrage. Blaine?
Yeah, Lester, not only gathering, but now kind of moving around. We understand that from the initial place where they were, they've now moved, marching several different places around Louisville. I want to go back to some of the reaction that we've heard, notably the reaction from an attorney for Breonna Taylor's family, Benjamin Crump. Earlier, we said that he reported and said that this is one step closer to justice. There's now a new tweet, a new couple of tweets that he's put out with a much different and a much stronger reaction. I want to read a little bit of that for you. He said, this is outrageous and offensive, talking about the decision, saying that if his behavior was wanton endangerment to people in neighboring apartments, then it should have been wanton endangerment in Breonna Taylor's apartment too. And he adds at the end, in fact, it should have been ruled wanton murder. So that's a very strong and a very different from the initial reaction that we understand we got via tweet from attorney Ben Crump. But again, Lester, really this echoes kind of the reaction that we've been hearing in Louisville from the people that we spoke to before this decision came down, to certainly the emotional reactions that we've been seeing from the people who've gathered, people who've walked by our cameras, just kind of shouting and expressing outrage at this. But certainly very notable that we're hearing this very strong reaction from attorney for Breonna Taylor's family. Lester.
And Blaine, I see the big heavy trucks blocking the street there. We've been reporting on the security precautions that were put in place in advance of this announcement. You say there are protesters in the streets. Have there been much in the way of police presence as these crowds begin to gather?
We have seen some police presence, and I also got to say, about 15 minutes or so ago, we saw 4 National Guard vehicles come down this otherwise very empty street. I think you saw the live pictures just a few minutes ago. That was the first outward presence that we'd seen of National Guard here in Louisville. We know that they've been at the ready, that they've been on standby now and ready to be deployed by the governor, but that was the first sign that we'd actually seen them physically here. Now, as for police officers themselves, as we've kind of walked through different parts of downtown, we've seen several kind of standing out of the way, a number of officers standing at different roadblocks as well throughout downtown Louisville. Lester.
All right. Thank you for that. And we saw a few people there with long guns, open carry state, but we note that. Let's go to Gabe Gutierrez now. Gabe, what is happening where you are?
Hi there, Lester. Well, we're here at Jefferson Square Park, where we were at a little earlier. As you can see, a much quieter scene. This is where protesters have been protesting for several months now. And the question is, what happens tonight? Lester, what we heard from the Attorney General, those were by far the most extensive comments that he's given to date on this case. And it did answer the question on what took so long. He tried to make the argument that they were waiting on all the ballistics to come in, and saying that the FBI decided that it was Detective Cosgrove that fired the fatal shot. But again, what we're hearing from protesters here, and what Blaine alluded to, that the family's reaction is, calling this outrageous and offensive. There will be a lot of questions over the coming days from protesters here. Why, if Detective Cosgrove fired the fatal shot, why he or any of the officers were not charged with anything more serious? Again, the Attorney General putting forth the case that officers were acting in self-defense and that the shooting was justified. But again, Lester, with the city of Louisville now in a curfew tonight, authorities are hoping that these protests don't turn violent. Lester?
Yeah, Gabe, thanks. There's a lot to work through. We know we'll have your reporting, of course, when I see you later on NBC Nightly News, and as we continue our coverage of this developing story. For now, I'm Lester Holt. Again, throughout the day, coverage on MSNBC. I'll see you later on Nightly. For now, I'm Lester Holt in New York. Good day, everyone.